Good morning and welcome to our Ascot Lloyd and Freeths first live joint webinar event. Thank you for joining us today. My name is David Malloy and I'm your host. Today we want to answer some of your questions around being an executor to help you prepare. Before we start, a few formalities. So today is live and we've done that so that we can take questions during the event. The questions will be answered a live Q&A at the end of the session. But please feel that you can write any questions in the box, Q&A box on the bottom of your screen. So you just put your questions in there and you can add those anonymously as well if you like. Any questions that we don't answer today, we will send out the answers via email to all our attendees for the event. So you'll be able to pick up them there. We'll also be recording today, so you can watch and share the video. And again, there'll be a link for the recording of today's live webinar, so you can watch that with family and friends again if you feel that's necessary. There will be audience participation, so we have 3 poll questions for the audience during the panel discussion, so just keep you on your toes, and I'll explain those and what you need to do as and when we come across those. But it gives us a bit of a take on our guests today. So a little bit about Freeths and a little bit about Ascot Lloyd. So Freeths is a top 50 law firm, 13 offices spread across the UK and has over 200 partners and directors. The family wealth practice is ranked as one of the top legal practices in the UK for wills, trusts, tax, probate and court of protection advice. They advise private clients and business owners on a range of contentious and non-contentious wealth preservation matters ranging in value from 500,000 to over 200 million. Ascot Lloyd, we are one of the fastest growing national independent advice firms with a regional and local presence across the UK. We have more than 130 fully employed independent financial advisors, and we look after over 8 billion of our clients' wealth. We hope you can find the next 45 minutes informative and helpful. Becoming an executor, or indeed deciding who should look after your wealth, is such an important decision and is often reached through an informal conversation over a meal with friends or loved ones. There's a lot to consider though, to ensure that the right things are in place to fulfill your wishes. Indeed, it can be a time when legal complexities can come to the fore, at the same time as needing to make important financial decisions when family emotions can also be running high. So we have 3 panelists today. I'm going to introduce the panelists. So to start with, we have Mark. Mark is an independent financial advisor for Ascot Lloyd. Mark began in financial services over 25 years ago and has seen most of the market and regulatory changes during that time. Mark joined Ascot Lloyd as an independent financial advisor just over 5 years ago, and Mark advises both corporate clients during his time, along with personal individuals and their families. Mark's areas of expertise include investment planning, retirement advice, both pre and post, along with tax matters such as inheritance tax and ensuring both individuals and their families are protected against unforeseen life events. Sally Goodger is the director of Freeths Wills, Trusts and Inheritance Tax Disputes team. Based in Oxford, Sally acts for individuals who are executors, beneficiaries, trustees, attorneys, administrators, and court-appointed deputies, dealing with a wide variety of contested matters, including executive disputes, will validity claims, inheritance tax claims, trust disputes, and mental capacity issues. And finally, Charlotte. Charlotte Digby is the director in the Freeths Trust, Estate and Tax team. Charlotte specialises in the preparation of wills for high net worth individuals and deals with complex administration matters. Charlotte is a member of the Society of Trusts and Estate Practitioners and has achieved national accreditation in advanced will preparation. So welcome panel. We'll start off with a simple question. This one's for you, Sally. So why is it important for people to make arrangements for their assets following death? And why should it give full consideration to choosing the right executor to do the job?
Okay, thanks, David. Morning, everybody. So that's a good question. Documenting your testamentary intentions in a will during lifetime means that upon death, your assets will pass to your chosen beneficiaries, subject, of course, to any claims against the estate or any will validity challenge. An important part of preparing your will and getting your affairs in order is choosing an executor and choosing the right one for the job. As you'll hear this morning, getting this right should mean that your estate will be dealt with smoothly and as cost effectively as possible. I think we all want to avoid a situation where our hard-earned money is spent on lawyers sorting out issues which could have been avoided had you sought the right advice as to your will and financial affairs during lifetime. So Charlotte, I'm just thinking this further forward. If you're appointed as an executor in a will, what are the different options do you have as an executor for acting?
Yeah, good question, thank you. Good morning, everybody. Quite often people think that if you've appointed your executors in the will that they only have one choice, and that is to act, but actually there's a range of different options available to them. So the first one is power reserved. So this is really a postponement of the executor's right to act in the estate administration and to obtain the grant of probate. So that might be suitable for someone who perhaps doesn't want to completely relinquish their role, but they also are not in a position to act fully in the estate administration at this stage. So if they wanted to step in the future, they would be able to, and they would be able to come on board, act in the estate administration and apply for a grant of probate. If you have an executor who simply thinks, well, I don't want to be involved with this at all, then they can do what's called renunciation. So that completely relinquishes their right to act in the estate administration. But people can't do that if they've already taken steps in the estate administration. So it's important for someone to consider that right at the very outset. So if they've started to deal with some of the assets of the estate or settling debts or something like that, then they will lose their right to renounce. And then obviously people can just take up their role and act in the estate administration and deal with everything that comes with, which we'll talk about later. But if I could just ask you, Sally, if you could expand on perhaps situations where you cannot act as an executor, or any further reasons why you might not necessarily want to be involved.
Yeah, of course, Charlotte, thank you. I mean, it's important. So there's two main things really to think about here. So an executor must have the capacity to act, as you've touched upon. So you can't be a minor, you need to be at least 18. You need to have mental capacity. You can't be bankrupt or insolvent, and you can't be in prison. So as well as having capacity, you also need to be willing to act. It can be quite an onerous job, so you need the time and willingness to do what needs doing. So for example, if you're ill, it might not be appropriate for you to take up office. You may consider that your work or business commitments are too much, that you just will not have the time to commit to it, to administer the estate. It might be impractical. For example, you may live overseas, all the properties in the UK, for example, and it just is an added complication to try and bring about the administration in a timely fashion. Another thing is that executors may have doubts as to the validity of the will and simply don't want to get involved with what that may entail. They may also be concerned as to whether or not there are sufficient funds within the estate to pay all the liabilities. A further aspect that executors should consider is any conflicts or potential conflicts. Wills come with families. Often there may be disputes already bubbling under the surface. They may already be on the surface, but you know that can give difficulties for an executor if they find themselves in conflict, particularly family conflicts. And again, some people might just think it's just too much to have to deal with and may choose not to take up office as an executor. It's important to remember that executors need to act promptly, they need to act impartially, and most importantly, they need to act in agreement. So an executor can't act unilaterally, they have to agree. So it's important to know that going forward, you and your co-executors can work together to bring about the administration. Another aspect of a reason why people might not want to act is if they are an executor and they may have a potential claim for financial provision under the 1975 Act. There may be a conflict situation and it may be best for them to step aside and let someone else administer the estate. There are ways as well, if an executor is in place and they are not taking steps to progress the administration, to remove them or pass over them before they take up office officially, before they get a grant of probate. That said, many people are quite happy to take on the role of executor and press on with the job. Moving on, Mark, I've got a question for you here. How do you believe a client's professional experts should come together to assist executors in their duties?
Thank you, Sally, and again, good morning to everybody. I think it's a really good question. I think the answer's in the question, and I think it is about working together as professionals. You know, we've discussed the onerous task of being an executor, and I think it's our responsibility to pool our knowledge, our resource, and our experience between accountants, solicitors, financial advisors, really to use all of our collective knowledge to help the executors. It's something I try to do where possible with my clients as well.
Thanks, Mark.
Excellent, thanks, Mark. Right, we're going to open up for a poll question now. So I mentioned at the start that we were going to do 3 questions out to the audience. So the first one is for you today is, how much thought have you given to choosing your executor? So you can just tick on one, either none, a bit, or a lot. And whilst you're doing that, once you've done that, just cross to the top right-hand corner. I'll just summarise the key points, the bits that we've got from the first part this morning. So the takeaways for me are who should be an executor. So age, health, etc., and why some people shouldn't act. My personal experience, one of my executors is my identical twin brother. Now, when we set our wills up initially, I had a young family, he had a young family, and he was absolutely the right person to executor my will. Now, he now lives in Australia. We're both very competitive. I absolutely expect to outlive him. So he's probably not the right person to have as an executor today. So, you know, I need to look at things like that. And again, that's not uncommon with people, where your executor, the person who you feel is the right person at the time, might change as your life situation changes. And the other point that Mark raised, which was co-executors and professionals supporting those executors, I think that's really important in terms of you know, getting the advice and looking at who can support me when I'm going through this kind of situation, and you know, especially where it's complex or there's more than one thing that you want to happen. It's useful to have that professional or co-executor support. So let's have a look at the results. So we've got, so the a lot has come up as the highest, which is excellent, and that means that we've got a fantastic audience today. So well done. It is something, as I mentioned right at the start, it is sometimes a conversation that people have, and it's very hard to say no when somebody asks you, will you be my executor, without knowing the full, the in-depth nuances of such a role. But thank you for that. So we're going to move on to another question, and again, moving on from what we've just mentioned. This is one for you, Charlotte. Could you tell us more about the duties and risks of acting as an executor if they decide to take up a role?
Yeah, sure. So the position of an executor carries with it quite a serious responsibility to administer the deceased estate correctly. And failure by an executor to carry out their duty can give rise to personal liability. So that's one paid by you personally as the executor, rather than paid from the estate assets. So it's really, really important that executors carry out all of their duties correctly and administer the estate correctly. Otherwise, they could be personally liable. So some of these duties are really wide-ranging. So from right at the very outset, you need to consider the terms of the will, locate the will, or find out whether there's been wills after you got the previous will in front of you that you think is the actual final will. Might not be. Then you have to register the death and make funeral arrangements as well, so carry out all of those administrative tasks, and make sure you're contacting all of the people who would like to attend the funeral. That can sometimes be quite a contentious point. And then obviously to locate all the deceased assets and work out what the value of those are, and have professional valuations carried out if necessary. And then also try and work out the extent of the deceased liabilities. It's very important that all debts are paid for the estate and that all creditors are located. And that's another area where you're at extreme risk of being personally liable if you don't take adequate steps to locate creditors. And then quite a big one that we're all familiar with is making sure that you carry out your tax reporting. So obviously the main one that we all know about is inheritance tax. there's likely to be some reporting that you have to carry out to HMRC, and that reporting can be quite extensive. But there's also other taxes to consider in an estate administration. So capital gains tax reporting and income tax reporting, those come up as well, and it's expected to make sure all of that reporting is carried out to HM Revenue and Customs. And then to look at the terms of the will and see what beneficiaries there are, and to make sure that you've taken all steps to locate the beneficiaries. Sometimes people aren't always easy to find. And again, you're opening yourself up to personal risk if you haven't taken all reasonable steps to locate people that are named in the will. And then finally, you're really preserving the assets of the estate, collecting them in, and making sure that the beneficiaries in that will, or under the intestacy rules if there isn't a will, are paid in the proportions that they should be. So the duties are very onerous, and there's a lot of them in an estate administration. Sally, if I could bring you in here, because it would be really interesting to hear if you've dealt with any cases recently where the executors haven't really played by the rules or adhered to their duties. It'd be nice if you could expand on that.
Yeah, of course. Thanks, Charlotte. Yeah, I acted for an executor as a sole executor quite recently. He was administering the estate of a late aunt. He collected the assets of the estate, and he paid the liabilities. But before distribution, he took it upon himself to try and increase the value of the estate assets. So what he did was spend the residuary estate funds on pens. So he invested tens of thousands of pounds in pens. His idea being that he could buy them and sell them for a profit, thereby increasing the sum available to distribute to the beneficiaries. Now, what he had failed to realise was that his duty as the executor did not extend to increasing the value of the estate assets. His duty simply is to collect in, pay the liabilities and distribute. So he thought he was doing the right thing. It's something we would have advised against had he sought advice before he made the investment, potentially an unwise investment, but he found himself in quite a tricky situation, having spent all the money when he had beneficiaries that all they wanted was the cash and to move on, and he was unable to distribute until he'd resold the pens and had the money in the bank again to redistribute. So wise tale there is just be cautious, seek advice, because you might think you're doing the right thing, but it might not be so as it turns out. Another example of a case that I've dealt with where I acted for 3 of 4 executors. So this was in relation to a homemade will. The 3 executors had fallen out with the 4th executor with regard to the interpretation of the terms in the will, such that we couldn't reach agreement, and we ended up in a 3-day trial in Bristol seeking the court's determination as to the interpretation of the will. The 4th executor wanted her legacy out of the will, and that's what was the root of the dispute as to whether it was a valid legacy or not, and agreement just couldn't be reached. And I think this is a wise tale, really. The testator could have probably avoided perhaps the fallout, most certainly a 3-day trial, if she sought advice during lifetime and had a professionally drawn will as opposed to a homemade will. So again, they're the sort of the things executors can face, which makes the job of being an executor all the more difficult. So Charlotte, just thinking about these potential pitfalls, how can these be avoided at the outset during the will making process?
So the will, I think when you're preparing your will or thinking about preparing your will, you should get it professionally drawn up by a solicitor. So we see a lot of homemade wills come across our desks, and that's when it ends up with you in Bristol at a trial. And it's just getting that right advice from someone who's qualified and can advise you correctly on executors. And when you're thinking about picking your executors, I would say think about all the family dynamics. So you might have 2 children, for example, who you think, well, it's an obvious one, my children should act as my executors. But actually, if they don't particularly get on, then they're not the right people to be appointed, because they have to agree on things together. And if they already have a rift between them, then unlikely to be able to get on after your death when there's money involved and money at stake. So also think about the characteristics of the people you're considering to appoint as an executor. So lots of people will come in and say, well, I've got 2 children, one's very good with money and the other one's just not very good at life admin and dealing with finances. So you might want to think that they might not be the best person to then deal with all of your financial affairs after you've passed away. And keeping those executorship appointments under regular review. So someone, 10 years ago when you appointed them might have been the ideal choice, but now their lives might have progressed on a bit. They might have small children, or they might live abroad, or might be in ill health. So they might not be now the best person to act in your estate administration. So just keeping it under regular review as well is a good one. And then if you do want to have your family in there, despite them perhaps not getting on that well, or despite them not having a good hold on financial matters, you can also consider appointing alongside them a professional executor. So that could be someone like an accountant or a financial advisor or even a lawyer who would be able to act with them and help them along the way. And then also they can be quite useful if disputes arise between executors. They can often act as a good neutral third party to help smooth the way a bit for people. So those are quite good things to think about when you're preparing your will.
Excellent. Thank you, Charlotte. We're going to have another poll question now, and then I'll do again another bit of a summary. So the question we have now is, when did you last review your will? So again, single choice, but if it was within the last year, within the last 5, within the last 10, or I haven't reviewed my will. So if you give that some thoughts, and again, take the box that's relevant to you. In terms of a recap, I think the types of skills of an executor might need is again a really important issue. As I mentioned before, I've been an executor as well, and when I had to be an active executor, the reason I'd been chosen was because of my skills in finance. The other person who was an executor at the time was more there because she'd known the person for a very long time, and it was the moral compass, I guess, and was there to make sure that the things that she'd wished to happen were going to happen. So again, I think that's quite nice when you've got that balance. Also, the personal liability of being an executor, I think that's something that people miss, because as we've mentioned before, it's something that if someone asks you to be an executor, the obvious answer is you're flattered, and of course I'll do that for you. But in certain situations, it can be quite an onerous responsibility. And also the case studies. I do love the case studies in terms of it does kind of give much more of a real life example in terms of how these things can work. And as panelists today, I'm sure that they've all got a number of different examples or scenarios where it's either gone very well or absolutely not. And again, that's why we did this today, to hopefully give you some examples of what good looks like. So should we put the results of the poll up? Let's see what we've got in terms of this one. So again, fairly mixed. I haven't reviewed my will is 26%, but the highest is I have within the last 5 years. So again, well done the audience. That's a great result. And I think again, the takeaways from today are absolutely keeping your will up to date is one of those things. So that's excellent. So let's move on. So I've got a question now for Sally. So what can you do if it's too late, Sally, and you have an executor in place who isn't dealing with the estate as they should be?
Okay, thanks, David. Yeah, I mean, that's a good question, one that crosses my desks reasonably regularly. Of course, executors are in place, probate, you think everything's going to go smoothly. For various reasons it doesn't do. You can have a situation where executors are falling out with each other. You can have a situation where beneficiaries are falling out with the executor, and it becomes quite clear that in order to progress the administration, something needs to change. Now, an executor can be removed from office. They can be removed by agreement and consent, and that can be relatively straightforward. Of course, you've got to remember that you need a new executor in place ready to take the role forward. There are situations where an executor refuses to be replaced for whatever reason. In that situation, it's possible to go to the court and seek the court's order for their removal or substitution. again, you need a willing executor to step up, and it might be appropriate for an independent administrator to take the matter forward. The thing to bear in mind is that if you get before a court on a removal application, the court put the welfare of the beneficiaries as a paramount importance. They also give a lot of consideration to the fact that the testator actually chose their executor for a reason. So they're the things that you need to bear in mind. They're not easy applications to make, they're costly, time consuming, and they can be quite stressful. So best to be avoided if at all possible. Sometimes that's just not possible. The other thing to bear in mind is the cost of those applications. As I say, they can be expensive. The costs are within the discretion of the court. And the thing to bear in mind again, an executor may in some circumstances be personally liable for the cost of that application, and that will depend on how reasonably they've behaved, and each case is different. Just thinking further forward, Mark, I've got a question for you, if I may. How important is it for executors to understand the underlying investments of an estate prior to taking any steps within the administration?
Thank you, Sally. I think Charlotte's covered this previously. Really vital that executors kind of pause and take advice prior to encashments, predominantly due to tax-related matters. Whilst clients of mine perhaps would probably fully understand the complexities of their investments and how they work, that's often not the case with executors. It could be that we've got financially inexperienced executors, people who really aren't familiar with the types of investments or pensions that they're surrendering. And if we do things in the wrong way, we could be opening ourselves up to capital gains tax. As Charlotte said, certainly inheritance tax, perhaps losing tax efficiency of certain products such as an ISA, and being aware, again, with inheritance tax planning, whether there are any associated trusts. So I think that whilst an executor might decide to go gung-ho and try and liquidate the estate for the benefit of everybody quite quickly, I think involving people and taking advice prior to encashment is pretty much vital, Sally. I think we've covered quite a lot of content already. So, a question to Charlotte, I suppose, is, when making a will, what would be the top tips that you'd recommend people to do, Charlotte?
Yeah, so I've touched on it already, but reviewing your will regularly with your solicitor is probably my main top tip. And you probably think I would say that because I'm a solicitor, but every 3 to 5 years, I would say, is a good time frame to stop and take it out of the box where you've kept it and think, right, what do I need to review this? Or is this still fit for purpose? Am I still happy that this does what I want it to do after I've passed away? And then also if you've had any life changes. So marriage is a key one, because marriage actually revokes a will in a lot of circumstances, unless you have a specific clause to prevent that from happening. So if you're thinking of getting married, or you have got married and you haven't gone back to look at your existing will, then you should really do that. And if you've had children, then you can think about obviously leaving them provision in your will, but also as well a guardianship appointment if they're still under the age of 18. Considering that in your will is very important, because they're your most important asset. And then if you've had any recent bereavements in the family and you're due to receive perhaps an inheritance into your estate, that's an ideal time to see both your solicitor and your financial advisor to get advice on your estate planning and see whether there's anything that needs to be done in your will, to make it more tax efficient. And if there's also been any changes in tax legislation, obviously we're in such a period of unknown, and inheritance tax has stayed largely the same for a number of years, but that could change off the back of the pandemic. And we did have a few years ago now the introduction of something called the residence nil rate ban. It's a change in tax legislation, which means that you should seek advice on your current will to make sure that it's the most tax efficient that it can be. And then another good tip it would be to have a really good record of your assets kept with your will and keep that up to date. So when you see your financial advisor, make sure that you come away with a good record of what your assets are, and then put that with your will and send it to your solicitor, or even ask your IFA to get in touch with your solicitor so they're connected. And then keeping a good record of gifts. So lifetime gifts, the particularly important one for executors to be reporting all of the lifetime gifts in the last 7 years to HM Revenue and Customs. So keeping a good record of what the gift was, who it was to, and when you made it, and making sure that that's also with your financial advisor and with your solicitor, because that's going to make your executors' lives a lot easier, because the reporting to HMRC is fairly comprehensive for lifetime gifts, and it's an area that they quite like looking into. So just, I've mentioned a lot, Mark, about how IFAs and solicitors can interact with each other. How would you interact with, say, someone who's been appointed as an executor, and what would you see the benefits of that being?
Yeah, thanks, Charlotte. I think that very often the first time I have a conversation with an executor is after a bereavement. I would personally like to establish relationships with executors, pre-bereavement, and ideally probably about the same time the will was either reviewed or the will was made. I think if you've got a professional relationship, it's about helping the executor make the right decisions at the right time, and provide support. And I think, when a client makes their will or reviews their will, it's a really good time for all parties to come together and at least be able to put names to faces, if nothing else. Simple things such as having a valid email address and a phone number that the executor can pick up and say, there's been a bereavement, Mark, can we get together and have a conversation? And, we are in different times, and these different times give you different solutions as well. And I think one of the things that I'm going to open up now is that where I have annual review meetings with my clients, which are by and large virtual at the moment, geography is no longer a consideration. Why can't we invite the executors to a meeting like we're having today and really share information between the client, the executor, and myself, and create that relationship and understanding to support the executor at a time that they need it most. I think that's really important, Charlotte.
Excellent. Thank you, Charlotte, and thank you, Mark. So we've got our final poll question now. So how many of our guests today have introduced their financial advisor to their beneficiaries or executors? So again, yes, no, or planning to. And again, that really comes off the conversation that Charlotte and Mark have just had in terms of how they work and what have you. So if you want to take some time to answer that, we'll just do the key points slide as well while you're thinking about the answers to that. The key things I've taken away from that part are the top tips regarding regular reviews. I think that was really, really important. The importance of the executor knowing about the assets and the investments. And again, from personal experience, rummaging around, trying to find share certificates, uncertain whether there were any premium bonds for the person who I was executor for. You have a responsibility, as we've mentioned before, as an executor, but you also feel that you can't leave any stone unturned, and that if everything was in one place and all neatly put together and people knew who your trusted advisors are, does make things slightly simpler. And as I say, I'm speaking from personal experience there. Involving trusted advisors in early stage, you might think, well, you would say that, wouldn't you? But that was one of the reasons for doing today's webinar. We absolutely believe that, because we've seen situations where it hasn't happened or it's gone wrong. Some people are very incredibly well organised and perhaps don't need that additional support, but that's not always the case. So that's why we always recommend it. So let's have a look at the response to that poll then. So have we introduced our executors to? So the largest is no, and again that's not uncommon for the reasons that we've mentioned. And again, it comes back to why we're talking to our guests today. So thank you for that. But then 27% is yes, so that's also very good. So thank you very much. Okay, what I want to do now is take some questions from the questions that we've had in today, and also some that were sent in prior to. So I'm going to start off with Sally, I think. So Sally, first question for you. What should executors do if beneficiaries are in dispute?
Okay, thanks, David. It's a good question, is that. So if you've got beneficiaries that are in dispute as to the terms of the will, what they're entitled to, etc., the executor must adopt a neutral stance. Okay, so they must step back and let the beneficiaries resolve their dispute. An executor is required to provide any information and documentation that may help the beneficiaries resolve the dispute, but maybe they should take a back seat. What an executor must remember, though, is that during that time they have a duty to preserve the estate assets. So there may be certain steps that need taking, but what they mustn't be doing certainly is making any distributions during that time. And it will depend on the nature of the dispute as to what steps can and can't be taken, and what may and may not be necessary for the executor. And I think, again, it will be important for an executor to seek advice in that situation. So that they make sure they're doing what they need to do, but they're not doing too much, just to protect themselves as well from any personal liability. I think it's important.
Excellent, thanks, Sally. So one from the questions that are coming in at the moment. So typically, and this was for you, I think, Charlotte, typically how many executors should one appoint?
Yeah, that crops up quite often. So actually only 4 can prove your will and act in the estate administration. So I would not appoint more than 4, but I would say the best sort of advice, best practice would be between 2 and 4. So if you have just one executor, if they've lost capacity, say, and they haven't finished your estate administration, or if they too pass away and they're still in the middle of your estate administration, that can present quite a bit of problems. It makes the estate administration a lot longer and a lot more complicated. Between 2 and 4 is probably the happy medium, because if you have too many, then obviously there's too many cooks in the kitchen. And people have all got to work together and make decisions and agree. But yeah, so 2 to 4, I should say.
Okay, thank you very much for that. So we've got one for you now, Mark. What documents should I keep with my will? And I think they're talking about financial documents on that one. So what documents should I keep with my will?
Probably the most comprehensive document you should really keep with a will is a copy of the last financial review, the fact find document. And really that's a catch-all document where all the client's finances are recorded: income, expenditure, assets, protection policies, absolutely everything should be recorded in that one document. From an executor's perspective, it's going to help the traceability of finding things like premium bonds, pension plans in payments, etc. So that's a really robust document that really should be stored with a will. Perhaps a copy of the last valuation report. So the executors have probably got one piece of paper detailing all of the valuations of a client's assets, and maybe that would give an idea as to potential for inheritance tax quite early on. Any trust deeds where things like life policies or gifts have been made into trust, that would be helpful to keep in there. And nothing wrong with the business card. I'd like to think that most my clients' wills have got my business cards very close by. It's an email address, it's a phone number, and then probably one of Sally's spare pens as well. That might be a good idea to keep with the will. Excellent,
thank you, Mark. Okay, we've got another one that's come in. This is a slightly longer question, so bear with me while I read this one out. I think it's one for Charlotte. I'm an executor for a friend who has a fairly large amount of money, and I'm worried about the fact that they will have to pay death duties before I can obtain probate. He is currently in a nursing home and has suffered from dementia. I have a power of attorney and have registered this with most of the financial institutions where he has his money. Would it be an idea to open a joint account with the other person with power of attorney and put the money in to cover his death duties?
So that's a really good question, and payment of inheritance tax is I get asked a lot about that because it is a worry for people, because to get your grant of probate so that you can deal with somebody's assets, collect in funds, sell a property, you have to have paid HMRC your first instalment of inheritance tax. But often you can't get your hands on any money until you've got your grant of probate, and so it's a bit of a circle, keeps going around. So there are certain different things available to executors to pay the first instalment of inheritance tax. So there's something called the direct payment scheme. So banks, if a deceased got money in their bank account, executors can submit a form to them and they will pay HMRC direct prior to the grant of probate from the deceased bank account, that first instalment. So that's quite a good one, and most big banks take part in that. If you've got family who have got spare money, they can loan that to the estate to pay the inheritance tax and then get repaid from the estate. So that's something to consider. And also there are other providers that do offer executors loans as well. So that's worth looking into. A complete last resort is asking HMRC whether they can actually waive it, that first payment, to be paid, so it be paid at a later date so that you can get your grant of probate. They will only do that if you provide them with really comprehensive evidence that you've taken all steps that you possibly can to try and find money to use to pay the inheritance tax. An important point about that question actually is power of attorney ends on death. So whilst you have a power of attorney in lifetime, when somebody dies, or the person you've got power of attorney for, when they die, your powers end and the executors take over. So accounts that you have as attorneys in lifetime, there could be some complications there.
Okay, thank you very much. Another one which just recently come in off the Q&As. So I've just given my daughter a sum of money for her wedding. Does this count as a gift? Who'd like to pick that one up?
So I can, or Mark, do you want to? I don't mind. Probably both going to say the same thing.
Yeah.
Depends how much.
Exactly, yeah.
You do, there is a marriage exemption amount, so it depends how much you've given away.
Excellent. So, and another one off the back of that, a similar kind of question. How far back should I go for gifts? So again, it comes back to record keeping, I think, on this one. So if you're an executor, how far back should you go? Should you be looking for gifts made to potential beneficiaries?
Mark, do you want to take that
Well,
one?
I mean, I would say I think we might be straying into inheritance tax here and about the 7-year rule, etc., etc. Yeah. But my general view would be as far back as possible to record any gifts, because if we're discussing inheritance tax, it might well be that the situation that the estate's grown in value. So maybe 5, 6, 7 years ago, the estate wasn't in inheritance tax and now is. So I would just say very much best practice any time a gift was made and what type of gift and where that gift came from. You know, was it a capital gift? Was it a gift out of income? I just think, again, a question that was asked previously about what records should I keep with my will. Every time a gift is made, it might be appropriate just to make a hard copy of that and date it.
Lovely. Thank you for picking that one up, Mark. Another one that's come in. When my friend was very ill in hospital in Spain, his daughter asked if he could go and visit, as she thought that her dad had said that he had made me an executor to the will. How do I find out if I'm an executor to his will?
Okay, I'm happy to take this one.
Thanks, Sharon.
I think the thing to bear in mind here is that a will is a confidential document. Okay, so there's no public record of it in lifetime. So unless somebody's told you that you're an executor and you've asked them and they might not want to tell you, there's no way of actually confirming whether or not you are an executor. The will only becomes a public document once a grant of probate has been obtained at the probate registry. Okay, so once somebody's died, an executor may disclose who they are and what, you know, the basis of the will, etc. But until that time, there's no way of finding out for definite. I think the other thing to bear in mind is that people change their wills. So you may be an executor 1 week. If they make a new will, and for whatever reason you may have fallen out of favour, you may no longer be an executor. So it's subject to change until death.
Excellent. Thank you for that. No one's come in. This one I think is for you, Mark. Well, it is for you because it says, Mark mentioned losing the tax-free status on death of an ISA. Can you explain the rules on this?
Yeah, it's one of HMRC's success stories, actually, David. It's what used to be the case is if you take the current ISA allowance of £20,000, if husband and wife had got ISAs each and his ISA was 200,000, in the event of his death, the tax-free ISA wrapper would be removed completely, and his spouse would have the 200,000 returned. Well, that's 10 years worth of ISA contributions lost, essentially. So it would take 10 years to drip feed that money back in there. What's now permitted is what's called an additional permitted subscription. So the ISA can be transferred back to the spouse, fully retaining the tax-free status of it. I think the other advantage is, and I think different providers may have different rules, but I think HMRC's view is that the ISA transfer actually avoids probate. So if you've got an estate that needs liquid cash, and in that example there was 200,000 there, that could be released without probate. So yeah, it's quite a generous concession by HMRC to allow ISAs to continue after death.
Excellent. Yeah, I think you're right. I think it is a really good thing. Next question, this one's for Charlotte. If a house is under probate, who would the executor appoint to value the house? So an estate agent would surely up the value, whereas an executor may want to be wary of the tax paid according to the value of the house. So again, it's that balance between whose value do you work on that case?
So if there is inheritance tax in point in your estate, I would always recommend that you get something called a red book valuation, which is essentially a chartered surveyor who's RICS qualified to carry out a full survey of the property, and they'll give you a valuation as at the date of death. And what they'll cover in that will be a lot more comprehensive than an estate agent's marketing appraisal. So they'll cover things like if there's any development opportunities on any land, or if there's any structural issues with the property that will affect the probate value of it. So having a strong valuation like that carried out by a chartered surveyor is going to put you in the best possible position when you're perhaps negotiating what it's worth with HMRC at the date of death, because HMRC do in fact have their own arm called the district valuer, which they essentially instruct to go out and value properties that they don't agree with the valuation that's been submitted by the executors. Now they do still do that if they've got a chartered surveyor's report, but it puts you in a much stronger position if you can submit to the district valuer, well, here's our RICS certified surveyor's report. It's a lot more comprehensive.
Excellent, thank you. I think we've got time for 2 more questions before we just finish off. So this one I think is for Sally. Sally, can executors claim expenses, and what is deemed as reasonable?
Thank you. Yeah, executors can claim their expenses. As to what is reasonable varies. You know, legal costs would be deemed reasonable so far as they're required and reasonable in themselves. Certain things wouldn't be so reasonable, and I think it really just depends on the size of the estate, the issues in the estate, and what additional expertise you might need to call in and steps you may need to take in order to bring about the administration. I think an executor needs to bear in mind that ultimately they are answerable to the residuary beneficiaries as to the costs that they've incurred in their duty as an executor. So I think it's really a case-by-case basis, but again, in any doubt, seek advice.
Excellent. And I think the final question, any questions we haven't answered, as I said, we'll send the answers direct to the person who's asked the question. So as long as we've got you put your name on that question, we can send that out to you. So the final question for today, should organisations such as banks be checking that an executor has capacity to act, or is that the executor's duty? And I think that's one for you, Charlotte.
Yeah, I think that puts quite a lot of onerous for banks and financial institutions. So what happens in practice is an executor will have the will that says they're appointed, they'll have the death certificate, and they'll submit that to banks and financial institutions to put, get probate valuations and put them on record as acting. If you're doing it in person, then you most likely need to go into the branch, present your ID, and then at that point, if it's obvious you don't have capacity, the bank may raise questions, but they might not. So I would say, as family members, if you know of someone who's acting as an executor who perhaps doesn't have capacity, then it might be a good idea to seek advice on that point. If you're going through a solicitor, then quite often, if I meet with somebody and if I feel as an executor, or they don't have capacity and I take instructions, then I'm not going to necessarily continue with them as an executor. So yeah, the banks and building societies, etc., are not always going to pick that up, though. I don't know if Mark, Sally, you have any input on that, but it might often.
I think it's difficult, isn't it? Because it is, like you say, it's a real onus on the bank to establish that, and I imagine they're not trained in spotting capacity on such matters. So I really do think it's important, if there are other family members and friends that have got concerns, to seek advice as to what to do in that situation. I mean, the other thing to bear in mind as well is the attorney grants that are an option as well, for someone to act in their shoes in order to deal with the administration.
Yeah, that's a good point.
Excellent.
I'd agree with you again, Charlotte. I think it really is a family responsibility. The family know the executor far better than banking staff or people over the telephone. Very, very difficult for banking staff in particular to make a judgment. They might not even be aware of the need that the executor's got to have capacity. They've probably not had that level of training or awareness. So I think the responsibility is a family one.
Excellent. Well, thank you. I think that's we're conscious of time, so I think that concludes our Q&A for today. So thank you, first of all, panelists. Thank you for your time and input today, very much appreciated. Hopefully, as our audience today, you found today informative and useful. I think it shows the importance of ensuring that you have a plan, you regularly review your plan, and that it's up to date. We will be sending out an email after today's event, as I mentioned before. It will have a link to the recording, so you'll be able to go through this again if you feel you need to, or want to share it with anybody. So keep an eye out for that in your inbox. The email will also include a link to feedback for today's webinar. So we would love you to be able to just give us some feedback. It helps us improve how we do these going forward, and any feedback is really valuable for us. So any comments that take about 2 minutes to complete, that will be fantastic. So thank you very much. If you'd like to talk to somebody about making a will, appointing an executor, or interested in taking financial advice, please reach out to us. And again, the email being sent out will include details of how to get in touch. So please feel free to do that if you'd like to. So thanks again for your time today. I hope you enjoy the rest of your day, and goodbye from me and the panel. Thanks very much.
Goodbye.
Bye.